The Siniard Law Show, answering your legal questions. Featuring attorneys Tommy Siniard, Bart Siniard, and your host, Aaron Dacey. This is the Siniard Law Show.
Hello and welcome to the Siniard Law Show, where we invite your legal questions and educate you on various areas of the law. Siniard Law is a father-son personal injury firm right here in the Tennessee Valley, focused on giving back to the community through legal education. One of the attorneys in the firm, Barnes Hayward, is joining us tonight, and Barnes is recognized by the National Trial Lawyers as a top 40 under 40 personal injury lawyer in Alabama. He is joined by attorney Nick Lough to talk about criminal law this evening. This ought to be a good one.
Yeah, I'm really excited about this one tonight, Aaron, and I'm joined by my good friend Nick Lough. Nick has been a prominent criminal defense attorney in Huntsville for about 10 years now, and he's probably more comfortable on set tonight than I am because, Nick, tell us about how you got into law and what you were doing before that.
It started here. Started at this desk. Started actually right back there when the studio was different. I used to work for WAFF for almost a decade, and I covered courts, police, and fire. And so this is like, I feel like I'm back at home here. It's been a while since I've been back at the desk, and this is fun.
So Nick, in addition to being a really talented criminal defense attorney, he also handles and is an excellent personal injury attorney, handles domestic and divorce cases as well. So we're really lucky to have him on the show tonight.
That is awesome. So what is the difference between a court-appointed attorney and a retained criminal defense lawyer?
It's a good question. So they're both attorneys, right? Court-appointed, and that's the system that we have right now in Madison County, and that may change here in the future. We may talk about that in a second, but court-appointed means the court has ordered that this attorney represent a defendant, a person that is charged with a crime. If they're retained, that means that that person that was arrested, that defendant, that they went out and sought somebody's legal services to represent them and
so
represent their interests.
So it's like private pay versus public.
Yeah, and so court-appointed attorneys are on an extremely reduced rate in the state, depending on what somebody is charged with, whether it's a misdemeanor or a low-level felony. That rate is different compared to a capital murder case, for example, and that law just recently changed a couple years ago. It used to be $70 an hour for a court-appointed attorney, and now it's $55 for a misdemeanor case. It's $80 an hour for a low-level felony, and it goes all the way up to $120 an hour with like a capital murder case.
But the person that's been appointed this attorney, they don't pay anything.
It
right?
depends on how the case is resolved, right? So if they enter into a plea agreement, for example, with the state of Alabama, and that person's ordered to pay court costs and attorney's fees, they're going to be paying that attorney's fees that are billed out through the state. And so court-appointed attorneys, that is not a free attorney, and I think people get confused at what all these terms mean. Mm-hmm. Look, I know some really good court-appointed attorneys. People come and retain my office all the time and retain me all the time. You get what you pay for. You also, you want to be with somebody that that you understand, that you're a team here, right? And so if you're with somebody that you're not comfortable with, or that maybe isn't explaining to you everything going on with your case, you may want to go talk to another attorney to see, is this a better team here? Because here's the deal. That attorney, no matter who it is not going to know as much as you do about your case. You lived it, you went through it, you experienced it. You know what it tastes like, smells like, feels like. So you might as well, if you're being represented by counsel, you want to make sure that you have somebody that's there that knows exactly, what makes you tick. You're a team there, and I think people forget about that. Sometimes my clients are able to point me in directions that I didn't know because I wasn't at the scene.
And there's been some discussion about a public defender's office. So what is the status about that?
Yeah, Nick, I wanted to ask you about that because Madison County is going to go through some changes, or there's some proposed changes to how that's going to operate. I know it is not a finished story. There's still a lot that's up in the air, but what can you tell us about what's happening with the public defender's office?
Yeah, this is the latest that I've heard. So we were alerted back in December that there was a vote that was made by a board here in Madison County that they had voted in favor of potentially bringing on a public defender's office here, so eliminating the court-appointed system. And then there was some challenges made by some defense attorneys that said that the way that meeting was conducted wasn't done correctly. And so a judge has recently come in and agreed with those attorneys that filed that grievance And so it's kind of up in the air right now about what happens next. It's definitely something that I think all of us are following, because if a public defender's system were to come in a public defender's office were to open here in Madison County, that is a radical change to how we do criminal defense services right now.
Well, if you have questions on this topic or any other legal topic, just email us at questions@siniardlaw.com, or you can call 844-7000-LAW and your question may be featured. Now to our legal tip of the week, jail scammers. Never heard of this. I mean, it's not surprising. Scammers are everywhere. So what is this?
Yeah, I had never heard about this until Nick and I talked yesterday. And apparently when people have their family members who are arrested and they're placed in jail, and there's a bond, family members are getting calls asking for money, and the people on the other end are telling them, if you pay us this money, we're going to get your loved one out of jail? Yeah,
they're posing as essentially bail bondsmen,
right,
and they are scammers, right? If you're getting reached out to by a bail bondsman, chances are that person is not who they say that they are. So you do never just wire money, send money, do anything. It goes... But if you think about it, it is the most stressful situation. Here I am, family members in jail. I've confirmed they're in jail because they're on, say, the Madison County Jail website. I know they're there. This person's telling me, hey, they have a bond. I got to get that person out. Take a deep breath, take a minute, call the bail bondsman company, call that company and confirm. It happens weekly where we hear from somebody that calls us and says, yeah, I got taken advantage by a scammer. They reached out to me because they were able to track the public record that showed that my loved one was in jail, and I wired them, or I sent them, or however that transaction happened, sent them some sort of money, and that money's gone or extremely hard to trace.
How much money are these people sending, these scammers?
It's terrifying how much money. Yeah. I mean, it's hundreds of dollars, sometimes it's more. And it's something that I don't feel like we report on enough, because look, we're talking about a sticky subject here. No one wants to talk about being arrested. No one wants to talk about their loved one being arrested. Not a fun day. Right? That's why people come and hire me. Like, it's not a fun day. You don't want to come to my office and talk to me about this, but we got to address it, right? Same thing with these scam artists. Nobody wants to admit they were scammed. Nobody wants to admit that they, were fooled or duped, but it's still happening. And it's happening, in my opinion, at an alarming rate. One time it's happening is too many times, and it continues to happen. And, how do you put a cover on it? It's so hard to stop.
Oh, that's terrible. So talk to us about the steps in a criminal justice case. What exactly happens? You're talking about bonding out, and like what happens when?
Yeah, so Nick, that's what I'm hoping that you can just walk our viewers through, because like you said, it is an unenviable position for someone to be in, for someone's family to be in. And I think a lot of people out there, they just have no idea what to expect. So what happens from the moment that somebody is arrested up until the time that their case is resolved? Just bird's eye view.
30,000 foot view, right? So there's two different kinds of cases in Alabama, right? There's misdemeanors and there's felonies. Aaron, do you know the difference between the two? I'm gonna put you on the spot here.
No.
All right, I didn't know the difference until I went to law school, so that's okay. Misdemeanor case means it's a case that can't be punishable by more than 365 days in jail.
Okay.
Felony case means that it's a case that could be punishable by potential prison time, up to life in prison if it's a Class A felony.
But not death.
Right? Well, if it's capital murder, that's a felony case and you could be put to death. I'm going to meet with somebody tomorrow. We have a case tomorrow in a capital case down in another county, and it's a death penalty case. So serious felony case. But that's the difference between the two. They're going to have different tracks, right? A misdemeanor case, you're going to have potentially an arraignment docket. You may have like a callback docket or a review docket, and then you're going to have a trial docket. Chances are that case is going to be over in a matter of weeks or months, probably not much longer than that. Felony case is a whole different story and a whole different can of worms. You get arrested, right? You're going to have a preliminary hearing date. You have 30 days from the date of your arrest for you or your attorney to go file for a preliminary hearing. And a preliminary hearing is a hearing to determine probable cause. Very, very low burden. From there, if probable cause is found, your case is going to be sent over to the Madison County Grand Jury. I'll tell you, the DA's office does a really good job here of trying to get cases forward, but it's the criminal justice system and we have limitations.
Nick, what is the burden for probable cause? Most people are familiar with beyond a reasonable doubt. This is totally different than that, right?
I call it a hunch.
Yeah.
It's a hunch that you may have or you could have done something wrong. Doesn't mean you did it, doesn't mean there's enough evidence for it, but it was enough to trigger an arrest, okay? So that's the easiest, most simplistic way that I can describe it.
All right, well, let's get to our viewer question. This first one tonight is from Janelle. She says, police stopped my car for a broken taillight and found a small bag of pills on the floorboard under the front passenger seat where my friend I had dropped off had been sitting. I was charged with possession of a controlled substance. What can I do?
So this is a possession charge.
Yeah, see it all the time.
But there are different types of possession in Alabama under the law.
That's right.
What does that look like?
Yeah, so, I mean, hold this pen for me. You're in possession of that pen, right? It's on your person, it's on your body. Put the pen right there in the middle of the table.
Okay.
All right, let's say that that pen is now cocaine.
Yep.
Okay, so now we got cocaine sitting in the middle of this table. It's sitting right there. Are any of us in possession of that?
Physically, no.
Physically, no. None of us are touching that, just like you were holding that a couple seconds ago. Let's say we're in a vehicle and we've got cocaine in the back seat of a car, or in this case on a floorboard. If we're all in that car, we're all in constructive possession, and potentially we could all go to jail for that. Talked to a bunch of high school students the other day about that. They were floored. They thought, well, what if I don't know about, and then we get into the details of a case. And we're talking about, did we know it was there? Did we not know it was there? Was it in plain view? There's all kinds of ways to look at this. But, at the most simplistic form right here, all of us are potentially in constructive possession of those drugs in the middle of the table.
Okay, so our Janelle, she's in constructive possession. She's not holding it.
Correct.
But it's in her car. Is she going to be criminally responsible for that?
Again, we see this question is a great question, because I see this just about every day in my office. Someone that's either, borrowing a car, in a friend's car, it just got picked up and drugs were found in the car and I was in my friend's car. Those cases are prosecuted. Now, how they're resolved is a totally different story. Again, just because you're charged with a crime doesn't mean you're convicted or guilty of anything whatsoever. But that's why getting with a good attorney who can pick up these fact patterns and say, did she know about it? Was it in plain view or was it hidden? Was somebody else in the car shortly before she was there or not? These are all questions that I would have in this type of case. And that's why it's so important to talk to your client, talk to people about what happened. I wasn't there, you weren't there, none of us were there. She was there. She knows what happened. So having that established rapport and relationship is so crucial.
Now, if Janelle wants to get in touch with you, Nick, how does she do that?
She can call me, she can email me. I'm really, really easy to reach. Just, go ahead and find me online and let's set up and let's talk about what happened and talk to this meeting, and have a meeting about this. But this fact pattern, this scenario right here is something that we see every single day. And it doesn't even have to just be, we used cocaine as an example. Someone's prescription medication. If I'm in a car and I drop a friend off and they accidentally leave their prescription medication, I could face potentially a felony crime for that. It's not my prescription. I'm not on the prescription bottle. Why is it in my car is the question that comes up. And that's where your attorney can better explain to you the dynamics of that case.
All right, awesome. When we return, we will discuss what people need to know once they have been released from jail.
Harrison Brothers brings together the best of North Alabama. Our curated selection of local art, fine crafts, and gourmet food are great gifts for everyone on your shopping list. We carry books by local authors, and our toys pique a child's imagination. At Harrison Brothers, your purchases support artists and artisans right here in the Tennessee Valley. Located on Huntsville's Courthouse Square since 1897, Harrison Brothers is more than a store. It's a tradition.
I got sandwiched between an 18-wheeler and a truck. During the accident, I lost my left leg. I chose Siniard Law because my granddad knew they had a great reputation. They were very knowledgeable. They were very sweet. We had a connection. They pretty much treated us like family. I would definitely recommend Siniard Law because they are caring and they will help you get what you deserve. If you've been injured, call Siniard Law.
Welcome back to the Siniard Law Show. If you would like to sign up for Siniard Law's newsletter, which provides free monthly legal tips, just scan the QR code or be sure to sign up at siniardlaw.com. Barnes Hayward and Nick Lough are with us this evening teaching us about criminal law. So guys, what happens when somebody gets out of jail? We were taken step by step what happens. So out of jail, then what?
We were talking about a felony earlier, right? And so we talked about, well, you're going to have a preliminary hearing. That's going to happen pretty quickly after somebody's, incarcerated and say they bond out of jail. From there, that case is going to go to a Madison County grand jury. It could take a year. It could take longer for a grand jury to determine whether or not there's a true bill indictment or a no bill of indictment. If it's true bill, then your case is moving on to circuit court, and you're going to have an arraignment docket. Arraignment simply means, are you guilty or not guilty, right? And that's all that they're asking at that docket. And then from there, depending on which judge that's assigned that case, every judge does it a little bit differently.
They're asking if you're pleading guilty.
Yeah, pleading guilty.
Okay, yeah.
Yeah, and so be prepared to plead not guilty. Again, it's the state's burden. We want to know, what the discovery is in this case. What evidence do they have against us? That's where you and your attorney are going to have those discussions outside of court. Hopefully you've had several meetings about that. And then from there, either you can work out a deal, and as the saying goes, there's 1,000 ways to skin a cat. So, it just, is it diversion? Is it a straight dismissal? Is there something in your case where you can file a motion to get it dismissed because of a technicality? Is it a plea agreement or something else? Or are you for trial? And if you're for trial, then your attorney needs to be ready to go for that trial. I love trials. We went to law school to go be trial attorneys. And so trials are the most fun. They're also the most stressful. Somebody's life is on the line, and you gotta respect that and treat that seriously. And I keep harping on it, but that teammate component of this, you gotta have a good relationship with your client, and your client has to have a good relationship with you, because when you go to trial, it's all hands on deck, and you are doing whatever you can to help that person.
All right, you mentioned bond.
Mm-hmm.
What is bond, and what are you seeing throughout the state of Alabama in the way that bonds are being set?
Mm-hmm.
Because it's a burden on the state and on taxpayers when maybe people who have been charged with crimes who arguably should be out on bond or not. They're in the system, we're having to provide for them.
Yeah, so let's break this down, okay? So bond, first of all, everybody in the state of Alabama, except for a few crimes, is entitled to bond. Capital murder, you may have a no bond, and that's constitutional. There's also several other crimes now recently based on Anaya's law where you may be denied a bond. They're violent crimes, they're high-level felony crimes. But at the end of the day, most cases you're going to be eligible for a bond. And that bond, it could be anywhere from a $500 bond. I had filed a motion here recently for somebody that's incarcerated on a $4.5 million bond. They're facing 3 counts of trafficking, right? Yeah. And so these bonds, you may be eligible for bond. Well, not everybody can make a $4.5 million bond. And that kind of brings us to step 2 of this. What we're seeing here, I think we're seeing excessive bonds. And I think we're seeing it for 2 reasons. One, I think it's really sexy to run on, hey, I'm gonna be tough on crime. I'm a legislator, I'm running for the legislature, and I'm gonna be tough on crime. And frankly, as a society, that's a decision that we need to make. Maybe we need to be more tough on crime. Well, the flip side of that is when we're really tough on crime, where people that are accused and haven't been found guilty of anything, there's costs associated with their incarceration. I looked it up yesterday. It's $55 a day for the upkeep of somebody in the Madison County Jail. Well, if you do the math, $55 a day, we have approximately 1,200 to 1,300 inmates right now. Over the course of a year, that's almost, if my math is correct, $25 million just to house people that haven't been found guilty of a crime yet, but are just waiting for their day in court. Now, some of those folks, obviously, that's going to be a big deal, right? Because those are violent offenses. Some people are not going to be eligible for bond. But just because you're poor or just because you're unable to make a bond, in my opinion, maybe there should be other ways that we could get somebody out of jail as they wait their 1 year or 2 years in court.
Well, I'll tell you what, I don't envy the judges that are placed in that position, who are trying to make the best decision, to protect the public. It's an interesting conversation.
You can see both sides in that situation.
Yeah, there's you can debate it all you want to, but it's a tough question to answer at the end of the day.
And the truth is, nobody wants to fund prison or jail.
It doesn't.
Taxpayers do not want to spend money on that. That's why we have overcrowding. So let's get back to our viewers and your questions. We have a question tonight from Alicia. She says, I was recently pulled over for not stopping at a stop sign on my way home from work. The officer asked if I would step out of the vehicle, and I did. He ended up telling me he smelled alcohol on my breath, and because I had nothing to hide, I took a breathalyzer. When it came back 0.0, he released me. My husband is adamant that the officer had no right to ask me to get out of the vehicle and told me I should never have agreed to answer questions or take a breathalyzer. He wants to know if I can sue the police department for violating my rights.
What do you think?
I love this question. I think maybe your husband's been watching a little bit too much TikTok.
Or crime shows.
And I'm glad to hear that nothing serious came out of this. But no, and Nick will get into this, but it sounds like there was a legitimate reason for the stop. Okay, and in the state of Alabama, so long as there's a legitimate reason for the stop, the officer can ask you to step out of the car, and he doesn't have to have, some specific reason to do that, right? And he says he smelled alcohol in her breath. Those questions are legitimate. Here's my question, Nick, because we all know that we have a right to remain silent. Criminal defense attorneys talk about this all the time. We tell our clients, be careful what you say. She says I had nothing to hide. She blew at 0.0. So what's the line between answering questions and keeping my mouth shut? How do people know when to talk and when not to talk?
Yeah, well, and there's red flags that go up here too, because you don't just, everyone thinks of DUI in terms of alcohol, right? But there's other ways that you can get DUI as well. And one of them is I was under the influence of maybe some prescription medication that impaired or altered my ability to drive. And so first question that I'm asking this client if they come in is, were you on any medication that caused the officer to think this? In this situation, it doesn't sound like anybody was arrested or any further, investigation was needed. But the officer has a duty to do that investigation, and the officer does have the ability to have you step out of that vehicle. You do not have to consent to field sobriety tests. You don't have to consent to a breathalyzer. If you've got nothing to hide, then by all means. But I would just advise people, understand what your rights are. Understand that you do have to comply with law enforcement to that point too. Just because they want you to step out of a vehicle and you didn't do anything wrong, step out of the vehicle. Now, if they want you to take a field sobriety test and they're accusing you of drinking and driving and you don't want to take that test, you absolutely do not have to, right? Anything you say can and will be used against you, in the court of law. We've all heard that over and over and over. But these types of cases, we don't know the whole story here. I would love to know more facts than what's provided right now to really get into, well, what was the right thing and the wrong thing to do. But at the end of the day, if we're not stepping out of the vehicle, they may charge us with an additional crime. Obstructing governmental operations, a Class A misdemeanor, punishable by up to a year in jail. That's something that they could potentially look at, right? Resisting arrest. If you're under arrest and you're resisting, they may look at that too. So, your inaction or inability to listen to law enforcement's direct order may result in more, hurt coming your way than the original stop for potential DUI.
So you say no to the breathalyzer or say no to the field sobriety test. What happens then?
Well, you're probably getting brought in,
yeah,
right? And your license is probably going to be suspended. Nick, I'm sure you see that a lot. Even in cases where somebody's had nothing to drink, they don't want to submit to a breathalyzer, probably because they don't test, the accuracy of the breathalyzer test. And then a field sobriety test, that's really based on the officer's subjective opinion, right?
Yeah, and at the Madison County Jail, for example, they'll bring you back there when you get booked, and they'll have you blow into an additional device down there to get what they say is a more accurate reading. The devil's in the details here, right? What are they accusing me of? Why did they pull me over? What have I said or not said? Did I take a test or not? What did that test show? I mean, all of those things are factors in all of this. These cases are never clean. There's always, muddy water that you're sifting through. Yeah. And so you really got to break these down point by point to get to the end of the road here.
Ooh, but the stress of being there and pulled over, my goodness. Well, thank you for that answer. And now let's check into Derek's email. He said, I recently found out there's a warrant for my arrest in Madison County for failure to appear in court. I didn't know I had a court date. Should I turn myself in, or is there another way to handle this?
Nick, you ever gotten that phone call?
Yeah, I feel like I get that phone call just about every other day. And look, I get it. Life happens. I've got kids at home, and my life is crazy, and my wife and I try to do our best, but I forgot to sign my son up for T-ball the other day, right? Not missing a court date, but it's easy to forget some of these things because we all have so much going on. And so here's what I would do if I was in this situation with Derek. I would go call an attorney immediately because they're going to be able to get a case number and tell the court through a motion exactly what happened. Sometimes just letting the judge know, hey, judge, I forgot. If you give me another opportunity, I'm going to be there. And you got to be honest. We're not here to tell lies. We're not here to be dishonest about this. You tell your attorney why you didn't go to court, and let your attorney file that motion. It's a motion to set aside a warrant sometimes. And look, I've had a lot of success with getting a judge to kind of see my side of it. They're people too. They're busy too. They know things happen. The flip side of that is it's a court date. You should know your court date. And it should be one of the most important things. I have my clients plug it into their calendars. I try to send them a reminder text, a reminder email, a reminder phone call if I can, just to let them know, hey, we got court coming up. In my opinion, I should care more about your case than you do. We should be caring about it with the same weight. And I really need people in court, right? So we never want to try to miss that court date. But again, it happens. When it happens, let's just make sure that we're being honest about why it happened and just don't make it a repeated pattern.
That this brings up another scam that has been happening in Madison County for well over a year. My wife got this phone call, but people are calling folks, pretending to be from the sheriff's office, telling them that they got a summons for jury duty in the mail and that they've missed their court date or their time that they're supposed to appear for jury duty, and then trying to scam them out of money to get out of the mess that they've created for themselves. I know that the Madison County Sheriff's Office has addressed this. Mm-hmm. It is a scam. The sheriff will never call you about jury duty, and so if you get that phone call, don't pay anybody any money.
And if you're worried about it, just call an attorney. If
Right.
somebody calls me with that question, that's a free phone call. We're here to help people. We don't want people to be scammed. We don't want people to be taken advantage of. And look, if you're ever concerned about something, just call an attorney and get an honest opinion. We do this stuff every single day. So we see it, we hear about it, we know about these scams. It may be the first time that you've ever received this kind of phone call. You don't know what to expect. Get somebody on the phone or get somebody over email that can better explain it to you, and then you can make an informed and educated decision on what's going on.
Yeah. Skepticism is our best friend in this case. Thank you both so much. We learned a ton, as usual, here on the Siniard Law Show. We appreciate it. Barnes Hayward from Siniard Law and our guest, Nick Lough, for all this information about criminal law. We look forward to hearing from you, our viewers, about any legal topic that you'd like to ask us. You can email us at questions@siniardlaw.com or call our voicemail at 844-7000-LAW. Join us next Sunday night after the late news. Good night.
The preceding was a paid presentation by Siniard Law Injury Attorneys, paid for by Siniard Law Injury Attorneys.